Good evening. This is Rahul Reddy. Every Tuesday live from Houston, Texas, we do bring in 1 hour and we do take live questions. Along with me, my business partner, Emily Neumann. Emily, what do you have today to discuss?
Today, we want to talk about companies, particularly consulting companies that are filing H-1B petitions for in-house projects that are actually fake in-house projects, fraudulent applications, how that can impact you as the beneficiary and how it can haunt you even a decade later. We'll also talk about this concept nowadays of switching from EB2 or EB3 into EB1 through the EB1C route as a multinational manager or executive. Who qualifies? What steps do you need to take? Do you need to move abroad again for 1 year and then come back? How does all of that work? We'll also talk about location changes for your H-1B and how that impacts your labor certification, I-140, or your 485 if that is pending as well. And then a common question that we get for those that are on H-4 EAD is if the H-1B holder, the spouse, changes jobs, what happens to the H-4 EAD? Is it still valid? Do you have to file an H-4 EAD every time the spouse changes job on the H-1B?
Emily, coming to this fake in-house projects, and these companies will come in saying that, yeah, we have a project, and they put it out something on their website, and then they keep telling that it is, but there is no revenue, there is no client, and they keep filing these H-1Bs. And I see a lot of people when they lose the job from good companies and they want to join some, so they want to move, they want to stay in this country though, they're choosing these wrong companies instead of moving into B2. They can move into F1, they can move to B2 for staying in the United States. They don't have to go into H-1Bs. A lot of these people that come to me and say, "Hi, I've been in touch with some consulting companies. They're going to file H-1B." So for them, they will pay the fees, filing fees. They'll pay, which is a lot, and they also will pay the salaries, which is it's a money laundering. It's a felony crime for participating in these things. Now, of course, you don't have time to prosecute these employees, but when the prosecution comes from the employers, they're running away to India and they are forming new companies with different people's name and fluctuating. People don't understand the long-term consequences. Even if somebody have been associated with this company, they filed the H-1B with this in-house project, got their H-1B approved in the in-house project. Later on, let's say they get a job with some good company, they can still haunt these people for collaborating with these fraudulent companies at a later date. How many times have you seen, Emily, where the first H-1B was being filed with this in-house project, and then later on, they're actually working for good companies, let's say Deloitte, let's say, Cognizant or Apple or whatever those companies, and they go and revoke the first H-1B, and then they go and revoke the Apple's H-1B also. How many times have you seen, Emily?
Yeah, I feel like I get one of those consultations almost every week.
And it's we suggest that don't associate with these companies, guys. If we are not telling that if they have a project, let's say, for example, the company has an end client, and let's say you interviewed with Coca-Cola company and they want to file H-1B, absolutely, go ahead with it. That's very good. If they're telling that they're going to file with an in-house project for a consulting company and that there are no clients, they're building something, and they're going to charge you for the filing fees. They're going to charge you for the. They're going to charge you have to, because you have to be on the payroll after within 60 days. You have to move to F1. You have to move to B2. Of course, you have H4 option. You can move to H4, or you have to be in H1B with a different company, and you have to be in payroll of that company. That means that you have to run the payroll, and for that you're doing one other crime by paying them the money and getting them money, which is a crime. We strongly suggest you don't do any of those activities. USCIS in its website in March of 2023 said that if you lose the job, you can convert into B2. While you're in B2, you can change back to the status of H1B without leaving the country. They have given that options. We have tried many times, had no issues in converting back into H1B once the B2 has been filed or approved. It normally takes about 2 to 3 months. You can file the same application online.
Yeah, I know that 60-day grace period is very short, but don't get desperate to file an H-1B transfer. You don't have to do that. You can file a B2 to buy yourself an extra 6 months of time to find that new real job. because if you file a transfer with one of these companies, you know, next time you go for visa stamping, even 5-10 years from now, if you're applying under the Dropbox, they might call you in for an interview and grill you at the consulate for hours about this company and what your involvement was and what the company did, whether you paid for the H-1B, whether you paid the taxes on the payroll, all kinds of shady things these companies do. So it can cause your visa to be denied. You can get grilled at the port of entry. You might have gotten the visa, no problem at all. And then you come into the airport and they stop you there and grill you for hours. And then even 10 years from now, it can come up in your 485 interview. We're seeing that now for issues that happened a decade ago for applicants where the priority date is current now and they're being interviewed. So don't make a desperate move when you have so many other better options. There's no need to go that route.
Let's go to the next topic, which is transitioning. As everybody knows that EB2 and EB3, the priority date is backlogged, and most probably it's going to take a lot of time for people to get their priority date current, though. And a lot of people, some people are taking a job offer either in India or Canada or some other country and coming back with the same company. Let's say, for example, your Tata consultancy company, or let's say Deloitte or whatever company, Apple, Microsoft, whatever company, and you work with a branch office outside the country at a higher level position, which qualifies as a multinational executive. You come back into United States again. You can file something called EB1C application. The company can file an EB1C application. A lot of people are doing it. A good number of people are getting success rate. We encourage people doing it. As long as the position is a multinational executive position and the company is willing to file the EB1C green card, it's worth taking the risk, guys. You know, we see a lot of people aging out children where the children are born in India, and by the time you get the green card, they may be aged out. That means that they have to swim the same thing what you have done a little bit longer than what you did. So you don't want to, you know, people don't want to give their inheritance of this bad immigration to their children. For that reason, also they take a risk. The only thing that you have to be careful is that if the position qualifies for EB1C and if the company is willing to support you in this application, these are the two things that you have to be careful. Emily?
Yeah, some people ask about if they're with their current company in the US and they're being promoted into a managerial role, can they qualify for EB1C? And in a lot of cases, the answer is no. So you need to be aware that it's not just about you being currently a manager. That's not the requirement for EB1C. It's number one, did you work abroad for 1 year as a manager or executive? Number two, are you being offered a manager executive job in the US now? And number three, do the companies abroad and in the US have a qualifying relationship? So if you were never associated with that company when you were outside the US and you're now saying I'm a manager, that does not work for EB1C. There are some people who worked abroad for the same company, came into the US maybe on an L1B for specialized knowledge, and have since been promoted into a managerial role. They may be able to qualify. We would have to look at what the job was that you did previously. Even if it was 5-10 years ago, we look at the 3 years before you entered the US to work for the US company. So you may be able to qualify that way. We've filed a number of those in our office, but we always have to be careful about what have you previously submitted to immigration about your job outside the US. Because at some point you would have filled out a DS-160 application for the visa where you specified what your job was, what your job duties were. And if you don't mention anything about that job being managerial, it's a little hard to go back now and claim that you were working in a managerial position. Same thing if you've already filed your PERM for EB2 or EB3. On that PERM application, you likely mentioned your experience abroad. If that job description doesn't have any managerial duties, it's a little bit hard to now claim that it actually was a managerial position. And we have seen USCIS dig into the DS-160, dig into the previous labor certification and the experience letters that were submitted with I-140s, and cause issues for that. Noting that discrepancy, notice of intent to deny, even notice of intent to revoke the previously approved EB2 or EB3 because they're claiming there's a discrepancy in your job description. So you have to be very careful with that. And then the third option would be if your company now is willing to send you abroad for 1 year, make sure, number one, that the position that you're taking abroad does qualify as a manager or executive. There's very specific definitions for those terms. So just because it's called a manager doesn't mean it's a manager in the eyes of USCIS. And make sure that the company is going to be offering you a position in the US after 1 year and they're willing to sponsor the EB1C. I have a number of people that have consulted me about, hey, I'm thinking about going abroad so that I can qualify for EB1C. My manager says they might be able to keep a position open for me or offer me a position back in the future, but they can't guarantee anything. Well, that's a little hard to go outside the country for an entire year, and then a year from now, your manager changes or company details change, and now your US job is gone. You have no managerial position to come back to. So be very careful with those things. Yes, it can be done, absolutely, but you've got to have the company on board and make sure the foreign position qualifies and make sure there's nothing in your past history that contradicts what you're saying now about your job abroad.
H1B location change. People ask this question. I have my labor and I-140 approval. My H1B, now I'm moving from A location to B location, which is a different MSA. Do I need to file the labor and I-140 again? First of all, if it's a consulting company, though, like including Deloitte, Cognizant, and all those other consulting companies, absolutely not, because there is a provision that they put it that if you move from, you could be working at multiple locations because of your consulting job. That's for consulting companies, is perfectly all right. Now, for the full-time jobs, though, most of the companies don't require. Now, some companies may require to file the PERM and I-140 again. It depends on, I would say more or less like the law firm, though. Most of the top companies like Google, Apple, Facebook, Tesla, and all those companies, they don't ask you to refile the labor and I-140. And the question comes in when at the time of the green card, though, the lawyer asks people to sign an affidavit that once the green card has been given, that you intend to move to that location where they are telling you to get the green card. Now, there are some company lawyers that mandatorily tells you to file the labor and I-140 again, but it depends on the law firm, though. And some select companies, though, 90% of the companies don't. Now, what does the law say? Law is not clear on it. I mean, as long as that when you get the green card, you intend to go there. This I'm speaking of only the full-time positions, not consulting position. The full-time position, the law says that if you intend to go, let's say the job was in San Francisco and now you move to Dallas, and once you get the green card, you intend to go, and the company intends to employ you in San Francisco, that is it, and you can get the green card. Is there enforcement? Will they check it? I've never seen them doing it. But as such, I was telling that there are some companies that may require you to file a PERM and I-140 for you to file the 485 application. Now, all this what I'm saying is about only to file the 485 application, not for extending the H1Bs, not getting the H4 EAD, not if you move to a different company using the I-140, the same company is I-140, you can use it. You don't need to file a PERM and I-140 again. Anything else, Emily?
Nope. I think last topic is if the H-1B spouse changes job, what happens to the H-4 EAD? Is it still valid? Do you need to file another H-4 EAD? So that EAD card remains valid until it expires, and as long as you're maintaining H-4 status. Your H-4 is tied to your spouse's H-1B, but not to a specific H-1B employer. So as long as the main H-1B holder is maintaining status with any company, you as the H-4 holder are considered to be maintaining status, which means your EAD remains valid as long as it has not expired, even if your spouse has changed employers. Do you need to file an H-4 EAD every time your spouse files an H-1B? you may want to. So in the situation where your spouse is filing an H-1B transfer and maybe you only have a year left on your current H-4 EAD, you might want to go ahead and file the H-1B, H-4, and H-4 EAD now all together to get a full 3-year validity, assuming you have an I-140 approved or you're not beyond the 6-year limit yet. So you can kind of file your H-4 EAD extension early and then avoid having a gap in your employment authorization, because the 180-day or 540-day grace period for, or not grace period, but auto extension doesn't work for every H-4 EAD. It only works when the H-4 I-94 has already been extended, which is very rare unless you do the margarita switch that we talk about all the time. So in that situation, you don't have to file the H-4 EAD because you're still valid, but you may want to, just so that everyone has the same end date and you can get that longer validity period without worrying about having a gap in your H-4 EAD employment authorization.
Emily, one question that came out very live right now, which I want you to ask. This question is coming from Durga. So the main applicant, which is the H-1B applicant, moved from company A to company B. The spouse is working on H-4 plus EAD, okay, which was given to company A. Which was granted to company A, which you said that even though the person is not working for company A, move to company B, they can continue working on the H-4 EAD. You said that clearly. What if the company A withdraws the H-1B? Is this H-4 and EAD still valid?
Yes, it still is. So the withdrawal does not impact it because the H-1B spouse would have already transferred and filed the H-1B renewal or extension or transfer with that new company. So the withdrawal of the old company's H-1B still has no impact on the validity of the H-4 or the H-4 EAD.
Let's go to live questions, Emily. Jancy is asking the question, are all the employment-based green card applications are getting interviewed? Is this a current trend? I would definitely say there has been a very uptick. That means more number of people are getting the 485 interview. And the people who have not been, people whose priority date is not current also are getting the interview. There's been a very uptick. If we were getting monthly, let's say, for example, 5 485 interviews, we're getting almost like 15 to 20 485 interviews. So there's like 3 to 4 times 485 interviews right now than compared to 1 year or 2 years ago.
Yeah. Mahesh says, how long is it taking for EB3 recruitment to complete on average? Does it take more than 4 months? It can. So it can take anywhere, assuming you already have the prevailing wage done, the recruitment part can take anywhere from 2 to 6 months. Maximum is 6 months because the recruitment has to be completed within 180 days of when the first advertisement is placed. Otherwise, you can't file the PERM. But it does take at least 2 months, mainly because the notice of filing has to be posted for 10 business days, so about 15 days. Plus, there is a cooling off period of 30 calendar days where no recruitment can be done except for one other piece of recruitment. So minimum at least 2 months to get that done. 4 months, I would say, is pretty standard.
Santosh is asking the question that his PERM was being filed in April of 2024. When can he expect the PERM to be adjudicated? Definitely somewhere between April and June of 2025 is when you can expect the PERM to be approved. Abhi is asking this question. My company is not willing to file H1B and H4 and EAD together. Is there a way where we can have the continuous employment done when the H1 and H4 and EAD together are not filed? What his question is that can the H4 EAD does not need to be interrupted in the job though? Yes, there are ways, but you need to fix it before. One, go ahead and file the H1B in premium processing. If they are willing to file the H4 though, go ahead and file H1B and H4. I see a lot of companies that are willing to file the H1B and H4 and they're not willing to file the EAD. In that case though, what you could do is that if the H1B and H4 gets approved and you are filing for the EAD extension, only EAD extension, you file the EAD extension before the EAD expires, you can continue working for 540 days even after your first EAD expires. That is one trick. The second trick is that if the company is not even willing to do the H1 and H4, then what you get the premium processing of the H1B approved, file the H4 plus EAD. Then after your H1, I'm assuming the H1 is already approved by the time. If the EAD does not come in 1 month before the EAD or H4 expires, though, you and your spouse can travel to Mexico and come back. And when coming back, the spouse, who is an H4 EAD, should show your H1B approval. They should grant the I-94 until your H1B expires. Now, you may want to rewind what I told and listen to it very carefully. And if not, if that situation comes in, contact us. I will get you how to get it done. Now, we want to make sure that there is no interruption in the job for H4 EAD. There are many ways, even when the company is not filing. The way is to travel outside the country after your H1B is approved. Make sure your spouse gets the H1B approval until the time your H1 is approved. It's very easy. There's a success rate of 97 to 98% when you fly to Mexico. People may ask the question, oops, my stamping has expired. My wife's H4 stamping has expired. Can I go to Mexico? Yes, you can still go to Mexico and come back. If you're going and coming back within 30 days and you're not applying for the visa, you can come back. At that time, they can show the H1B approval of the spouse and get the H4 approved, extended. And based on that, you have this 540-day rule.
Kelyan says, my L2 visa is expiring August 19th, and I've already filed my L2 extension on August 5th. Can I continue to work before getting my approval? This is a little bit of a gray area that came up because we no longer file L2 EADs. The L2 spouse is authorized to work based on just being an L2 status and having that L2S I-94. However, the L2 does not have the automatic 240-day continued employment authorization like the L1 does. Similar H1 and H4 does not, the H4 does not get that. So unfortunately, no, you need to have the L2 approval in order to continue working. So we always recommend filing the L1 and L2 extensions as early as possible and filing in premium so that you can get both of those approved in time.
Money is asking this question. He filed H1B, H4, and EAD together. H1 and H4 is approved, EAD is pending. Can the person continue working? If it was an H4 EAD extension, though, assuming that the H4 EAD extension has been filed before the expiration of the EAD, though, yes, they can work for 540 days. But if it's only the initial filing of the H1 and H4 EAD, that means it's not an extension of EAD, they cannot work. But if that's the case where it's not an extension, you can contact our office and we will be able to get it, because there is a class action suit under which the USCIS agreed that they are going to approve the H1. If the H1, H4, and EAD is filed together, they said they're going to approve all of those things together. And so we can always remind them and then get that EAD approved. That's only in case whether it's not an EAD extension. If it's EAD extension, you don't even have to worry about spending consultation fees on us, because she will get the 540 days extension anyway.
Vibob says, similar to the H-1B rule, can an AOS EAD holder be self-employed with more than 50% ownership for a 485 interview or for I-485J purposes? Yes, the USCIS policy guidance makes it very clear that for AC-21, which is applying to your I-485 portability, self-employment does qualify, and you can be the 100% owner. So you can select the box for self-employment on the 485J. You just have to be clear that the work that you're doing as the business owner is in the same or similar occupation that you were originally sponsored for. So you can't go from being a software engineer to I'm going to open up a McDonald's and be the franchisee owner and run the McDonald's. It still has to be in IT, but other than that, you could definitely do that.
Question is coming to V. Putis. He's asking the question, does I-485J consider to be a sponsorship? Well, we consider that we consider that it is a confirmation of the job offer. We don't consider that as a sponsorship. It's just a confirmation of job offer. Tanupriya has this question: is the 485J approval needed for getting the 485 approved? No, it's not needed. We've seen so many cases that it won't be required.
True Human says, I've not received my dependent's extension approval notice, either the hard copy or a soft copy. It was approved back in February 2024, followed up with USCIS multiple times. How can I get it? The most likely thing that you're going to have to do is file an I-824 application for a duplicate approval notice to be issued. I believe the filing fee is now close to $700, and it does take a couple of months to get. The other thing you can do, which I've had success in the past, but also not had success, is reach out to the USCIS Ombudsman. You have to fill out the DHS 7001 form. You can fill that out online. Include all of the information about the service requests that you put in, and tell them that you never received it, you followed up multiple times, you're not getting any kind of response. They may send it to you, but I expect nowadays they're just going to tell you to file the I-824 because it's been so long. They don't have that file just sitting around to be able to reissue you the approval.
Is there a possibility by any company who sponsors F2 to employment? Yes. You can have the H1B, and there are other things if you're qualified for O1, and there are other things need to be considered too. Yes, people on F2 can directly file a H1B. Absolutely not a problem. The question that comes from Sandeep Viparthi, he's asking, can the EB2 priority date be ported to EB1C? Yes, yes, and yes. It can be ported to EB1. Absolutely not a problem.
Santosh says, I have my PERM filed April 2024. When can I expect the approval? May 2025 would be my best guess, assuming that there is no audit. Processing times are not getting any better. Based on our lawsuits, I don't think they have any intentions of making the processing times any better. I don't think the new flag system has made them any better. So yeah, I think it's going to continue to be 12, 13 months, if not longer.
You sounded as if, Emily, that the lawsuits are the reason for them to delay.
Oh, no, that's not what I meant. No, we filed lawsuits because of the delay. And as part of that, we were able to get some testimony from higher ups at DOL about their processing, internal processing, and kind of what they feel about the delays. And they made it pretty clear that they could care less that these are taking a long time. So
it's more like political will right now then?
Yeah.
Than lawsuits. Okay. Ahmed is asking the question. He is working for company A. He got the H1B approval with company B. His question is that, what if he choose not to join company B and he sticks with company A? Is that going to be any problem for his immigration? Absolutely not. It's not going to create any problem, none whatsoever at all. Since you never joined company B, you don't have to mention about this company B ever, anywhere on the immigration forms or anything like that. You don't have to. No, it's not going to cause any problem whatsoever at all for your company A's H1B, and you don't have to mention to company A that this thing happened.
Viraj says, I got the EAD AP combo card for 5 years. And when I enter the U.S. on advanced parole, CBP gives me 1 year on my I-94. What happens after that 1 year? Do I need to renew the AP? Can I still be in the U.S. or am I losing status? So that's the only time you can ignore the date on your I-94 is when you've entered on the advanced parole and they give you that 1 year. As long as your 485 is still pending, you can stay beyond that 1 year. You don't have to file anything. You don't need to take any action. You're still considered to be in adjustment of status. You do not need to renew the AP until the 5-year expiration on your actual card.
Yogita has this interesting question. has prior to date has a retrogress, so she is on adjustment of status EAD, and she's not an H1B. How can she bring the spouse to USA? This question comes up very frequently to us. Yes, you can get back to H1B. How do you get back to H1B? I'm assuming that you have an advance parole because you said you have an EAD. Most probably you have an advance parole. The company can file the H1B. However, to activate it, you have to go to the consulate and then get the stamping in the consulate. Once you get the stamping in the consulate on H1B, your spouse will be eligible to apply for the H4. Now you can bring the spouse on H4, and good part is that as long as you maintain the H1B, the spouse can maintain the H4. The spouse can get the H4 EAD under adjustment of status. If you maintain the H1B status, you can get the H4 EAD. And when and if the priority date becomes current, you can have your spouse apply into the adjustment of status. You can apply the adjustment of status.
Kieran is on H1B. His wife is on H4. They both have the GC, EAD, and AP expiring soon and wants to know, can I choose not to renew the EAD and AP? Are there any disadvantages to not doing them? You can choose not to. You don't have to do them, but I highly recommend it, especially because there's no filing fee, assuming that you filed your 485 before April 1st, 2024, which I'm assuming is the case since you have an EAD that's already expiring in September. Why do you need to keep renewing them? It's always good to have backup options. During the Trump administration, during COVID, there was a ban on H-1B visas. If you traveled, you were stuck outside the U.S., you could not get an H-1B during that presidential proclamation unless you qualified for an exemption from it, which was a hassle to go through and took weeks to process. If you had an AP during that time, you could just come back on AP. No restrictions on AP. So same thing with H-1B versus EAD. If you're on H-1B and you lose that job and you can't find a new job within 60 days, you could instead rely on your EAD. So there definitely are reasons to have both, and especially because there's no cost to renewing them both, I definitely recommend it for everyone.
Anil Raju has this interesting question. Why nobody is looking into recapturing of the unused green cards? We can't wait ever until these drastic changes are bought. Agreed, completely agreed. Now we are looking into it. We made some voices. Tim Cook, the Apple CEO, did make some voices on that. We had Bill Gates make some voices. That the people who are not making the voices are you, Anil, and the people like you who are not making voices. Not us, not the CEOs of the company, though, because most of you guys are not writing letters to the congressman. You're not doing any effort to contact the administration to have recaptured the unused green cards, not counting the family members. Having the EAD given to those people who are having the I-140 approval for at least if their I-140 is approved for 2 years. These are all these changes. Look at the bottom of the links that we are being given. Have you written those things? Had you had your friends written those things? Put an entry rule in your home. Anybody who doesn't write those letters cannot enter into my home. You are the person who is affecting. Now, there are some immigration communities that do like this. In the time of Obama administration, later on also, we had these dreamers, the people who came under 15 years old, and they got their EADs. It's 1 million people got the EADs. Now, most of them still are in the EADs, the same EADs granted by them. And they did make voices. They made those. They went to the churches. They went to, even in the marriage places also, they paused the marriage and they delivered the speeches. The students and kids delivered the speeches. That's how Obama administration was moved and bought it. But our community is not doing it. The affected community in this one is the Indian community. No other than Indian community is there. We are not comfortable. When I go into these Indian community meetings, it's all about movies, and I don't know what they speak about. We try to speak with the community people and try to give us some time. And then Emily, last time I took Rebecca to the big meeting with 20,000 people attended. How many people attended our meeting? 3 people. We put a rule that you have to write letters to come into. Only 3 people attended. While for the movie stars, there were like 10,000, 15,000 people attended. What can we do? If you're not willing to help, there's nothing we can do. Yes, I agree with you that you can't wait because until the drastic changes comes, we can't wait for the Congress to do it. We need to have this administration do it. But where is the effort from your side, Anil? Where is the effort from your colleague's side? Where is the effort from your family side? Where is the effort from your friend's side? So you need to act on it. You need to take the charge. And the drafts of all those things were being given at the bottom. Please take a look into it. They have given, not counting the family members and not counting the family members, using the unused green cards and giving the EADs for those people whose I-140 is approved. The links are there. Please work on those things.
Shreya says, is it advisable to try EB1C on an L1A or an H1? Either one's fine. You can even do it on an H4 EAD. No problem at all. It does not matter what current visa status you have. You don't even have to be in the US to file for the EB1C I-140. You just have to have a job offer from the US company that meets all of the qualifications. Now, you may want to consider, if maybe you have a weak case, applying for an L1A first to see if it gets approved. Then that gives you a little more confidence that the I-140 should also get approved, because they are the same requirements, but they're not exactly the same standards. And there are a little bit more requirements for the EB1C versus the L1A. But no, you do not have to be an L1A to get an EB1C approval.
Okay, one second.
Srikanth says, changing status from B2 to H1B, where can I get my stamping? If you entered the US on a B1 or B2 visa, you have to go for your first H1B stamping in your home country. They won't accept third country nationals in other countries in that situation.
Ram is asking this question. His 485 has been rejected. It seems the officer did not read the details, understood that the EB1 is, the priority date of EB2 is not ported to EB1. Looking to refile. Ram, I think so the best way would be to do the motion to reopen. That's definitely a better way. And then if you want to, it's up to you. If you want to file a parallel in other 485 application, that's up to you. Motion to reopen is a good thing though. Also, I would do the freedom of information to get the details of your file to make sure that your I-140 EB2 is also there, so that you can provide it to the USCIS official. Look, this is there for me. The I-140 is already approved in EB2. I should have been given. So yeah, I mean, refiling is one of the options, definitely, but I would also think of filing a motion to reopen.
Pramila says, I have an H-1B with my current company. If I exit and join the qualifying company abroad as a manager, what's the process for me to return to the US on the current H-1B? Well, number one, I would ask, is your current H-1B for a managerial position? If it is, and you're going to go outside the US and work as a manager abroad for 1 year, you need to make sure that you have more than 1 year of validity left on your current H-1B. So if you have, say, 3 years on your H-1B right now, your H-1B is for a managerial position, you go outside the US for 1 year, you can come back on that existing H-1B, assuming you have the visa stamp, no action needs to be taken. However, if your current H-1B is not for a managerial position, you're going to go outside the US and you're going to come back to the US as a manager, they are going to need to amend the H-1B for your new role in order for you to come back into the US. And then my other question would be, when you're going outside the US, or do you mean to work for the same qualifying company of the company you already have your H-1B with? If that's the case, all of those things I just said apply. But if you're going to go work for a different company, completely unrelated, and want to come back to the US, the US company that's related to your foreign company would need to file a transfer for you to be able to come back to the US on that H-1B.
Vitali from X, which is Twitter, has this question that his I-140 is denied because of RFE ability to pay. Can I get the approval? Can he refile the application? Does the PERM expire? First, once you file the I-140, even if the I-140 has been denied, even if the I-140 has been withdrawn, the PERM never expires. There is no 6 months rule for it at all. You can refile the I-140. You may want to have Ryan Vick from our office. I mean, if that guy, I would consider the best immigration lawyer for the ability to pay in the entire United States. He reinvented the ability to pay. That's what I would say that. Now, how would I say that? Ability to pay can be documented several different ways. One way is that, of course, the person is getting the salary, what is being prescribed. Let's say labor certification salary is $200,000 and you're getting $200,000. Not a problem. You'll get an approval. Everybody will get an approval. Now, if the person is not getting the $200,000 salary, the guy is getting $150,000 salary, and the company has a profit of $75,000, and they don't have other liabilities from other I-140 approvals. So this 150 and 75,000 will be good enough to get an I-140 approval because that's more than 200,000. But what Ryan Wick has did is that, and especially this ability to pay, they go into all the employees and find out how many I-140s were being filed, who are the people who are not getting paid, and all those things. The way he calculates is that if the priority date has been established on July 1st, the July 1st though. So what he says is that for that year, from July 1st to December 31st, if $200,000 is the prevailing wage, okay, and you're getting $150,000 on an average, you got $75,000 from July 1st to you got $150,000 from January to December 31st. But the prevailing wage should only be calculated from July 1st. That means that you actually got overpaid because you're supposed to get you're supposed to get 100,000 by the end of the year, but you actually got 150. There's a $50,000 extra. And there are very many different calculations that did it. He's been very successful. You may want to have him file your I-140 again. He will tell if it's definitely something that he's going to lose under all circumstances. He will tell you that it's not worth for you to refile, but he is the best guy to refile the I-140 application. Ryan Wick, his name is.
Muthu says, my H-1B visa is stamped in my passport and I got laid off. I filed an H-4 and got the receipt. Can I travel to India while that is in progress? I mean, yes, you can. You always have that option. But when you file a change of status from H-1B to H-4 and you leave while the application is still pending, your change of status will be automatically abandoned. That means your H-4 application is going to be denied. Now, that's fine because you're outside the country. So how do you get back in? You go for H-4 stamping based on your spouse's already approved H-1B, and you come back into the U.S. on H-4. You can then file a change of status back to H-1B whenever you get the new job offer.
Sandeep Viparthi has this question. How back can we go for the priority date? For instance, EB2 is 2016. Can I do the EB1C in 2026? Absolutely, you can. I would put a limit of 90 years you can go back. Why not 91 years? You'll be dead. You won't be alive by that time.
Yash says my PERM was filed on May 5th, 2024. My H-1B expiration date is May 23rd, 2025. What should I do if my PERM and I-140 are still not approved by May 2025? You are totally fine because your attorney was smart and knew that you needed to file the PERM at least 365 days before you hit your 6-year limit. Your PERM was filed May 5th, 2024 and will have been pending for 365 days by the time your H-1B ends May 23rd, 2025. That means you're eligible for a 1-year extension based on the pending PERM. No problems at all with that.
He's asking the question, Lakshmi is asking the question, can the H-4 EAD spouse continue working on USA if the H-1 person leaves USA? That depends on what you mean by leaves USA. Does it mean visiting outside the country, or he completely leaves the country? He completely abandons the job and he leaves the country. The H-4 EAD cannot stay in USA. The H-4 EAD cannot work. But if he's just going, the parents are old, parents are not doing very good, and then he's going there for 2 or 3 months and coming back and visiting India or some other country, absolutely fine for you to continue working on H-4 EAD.
Rishi says, I have an H-1B I797 approval and visa valid till 2026. If I move out of the country for 1 year, can I re-enter to the USA with the same employer or even a different employer? And if a different employer, what documents are needed? Yes, you can. Since you've been counted in the cap before and you've not used up your 6 years, you can come back and get the remainder of your 6-year limit. If you're coming back with the same company in the same job in the same location, you can just come back on your valid visa. No action needs to be taken. If you're coming back with a different company, employer B needs to file an H-1B for consular processing. Once it's approved, you can use employer A's visa stamp that is not expired to enter with employer B's I797 consular approval, and then you can immediately start working for employer B. You do not have to go through the lottery. Now, because you were outside the US for 1 full year, you technically could go through the lottery if you wanted to get a fresh 6 years. But most people don't want to go through the lottery again because the chances are pretty terrible of getting selected. So you can always use that remainder option.
Viput has asking the question, very good questions he's coming with. On the AOC EAD, when you're searching for jobs, when the question is, do you need sponsorship for the role? I'm going to answer no, because we don't consider 485J as something that's a sponsorship. That's number one. Number two, you don't need the company to file a 485J supplement immediately. You only need it if there is an interview or in some very rare cases when there is a 485 RFE, but otherwise you don't. So if you're moving from company A to company B, do you need to file the I-485J immediately? No. Do you need to do any paperwork? No. All you need is to show EAD and start working for the company as long as the new job is in the similar profession.
Santosh says, my H1 and H4 extensions are approved, but the H4 documents were misdelivered by USPS. Can we still apply for the EAD for my spouse without the physical copy? Yeah, you definitely can file it. You're going to get an RFE asking for a copy of that approval notice, even though USCIS has it in its own records. But you can still file it. It's not going to be rejected just because you don't have that in your initial filing.
Sharda is asking the question, if the H1B person loses a job, can the spouse who's an H4 EAD continue working? Up to 60 days, yes. But after 60 days, the person loses the H1B status. Since they lose the status of the H1B, the H4 loses the status. So they have to move to a different status. For example, if they move to B2, then the H4 is not valid for you. You have to move to B2. If they move to F1, you have to move to F1 or F2. So that's only up to 60 days they can.
Avinash says, if an H-1B is picked up for fiscal year 2025 in the lottery, but the STEM OPT is valid for another 2 years, can we continue to use the 2 years of STEM OPT and use the H-1B later? Yes, that can be done. The H-1B can be filed for consular processing, which means once it's approved, it does not take effect until you actually exit the US and apply for the visa stamp and come in. That allows you to continue on your STEM OPT. I urge you to be very cautious in that because you can't predict the future. And if in the next 2 years, while you're on that STEM OPT, that job goes away, your H-1B is gone. You can't use it with another employer because you're not counted in the cap until you've either got the H-1B visa stamp or been granted the change of status to H-1B. So you can save your 2 years of STEM OPT and eventually have to go through the lottery again. So definitely tread cautiously there. And if your employer's telling you, oh, you can save on the taxes if you stick with your STEM OPT because the employer wants you to not get the H-1B yet, run away. Don't do that. Go ahead and ask for the change of status. Saving on the taxes is not worth potentially losing the H-1B that you won the lottery for. Knowing how many people these days have to go through the lottery 3, 4, 5 times to get picked.
There are a lot of people who are repeating the questions, but sometimes the question, we cannot understand it clearly. So try to rephrase the question. That will be much easier though. The person is saying, can you file H1B and H4 together at the same time? What do you mean? Is it in the consulate? Is it here or what? Is it yours and your spouse's? So please rephrase the question. That will be much better though. People who are working in, this is from Satish Kumar, people who are working in IT, information technology, are they eligible for national interest waiver? Yes, they are eligible for national interest waiver. I mean, there is no prohibition that the information technology people cannot be eligible for national interest waiver, but there are other factors that we have to prove. Are they in the national interest to stay in this country, though? Definitely, there has been recently, the USCIS has been more lenient towards IT professionals as compared to previously. Yeah, but you just because let's say you did a master's degree and you're just doing an IT job in Microsoft, are you automatically eligible for information technology for national interest waiver? No, you must have some significance that your work that you're involved is somehow in the national interest of United States. We have to prove that to get the NIW.
Sundeep says, is there a limit on how far back in time the priority date remains portable? For instance, can a 2016 EB2...
I covered it.
Oh, you got that one already?
Yeah. Can you do masters in USA while on H1B? Money is asking this question. Absolutely, you can. I mean, you can work full time and go part time doing master's degree. You don't need to convert into F1 visa. You can be on H1B and still do masters. Absolutely not a problem.
Test Learning says, my 797 got misplaced. Can I use a colored I-797 copy for an H-1B Dropbox appointment? Yes, you don't need the copy at all because they are able to look all of that up in the PIM system. You should be totally fine with that.
No. Okay.
Chandu says, my employer resides in state A. I reside in state B. I'm on H-1B and my LCA has my home address. But in my payroll, the state taxes are deducted per my employer's location. Does this affect my stamping? It should not affect your stamping, but that is not the way to do it. Your employer needs to fix that. They need to always run payroll based on where you are actually working. It has nothing to do with the company's location.
A question that comes from Anusha, and this kind of question keeps coming up to us very much though. Can we apply NIW I-140 working on the chip tech company? Of course, we know that nowadays that is the hot item, the chip industry, and we see the future is in there, or at least the people think. So by just working in the industry, though, you would not be automatically qualified. We need to see your role, how critical you are in to get that to your role. So, for example, if I'm working as a chauffeur driving a car for a chip industry, will I get an NIW? No. But if I'm working in the chip industry, designing the chip industry, let's say, for example, most of the chips are made in Taiwan, and now you're designing something like a master thing in Arizona, and they're going to have a thing, and you're one of the critical part of it in designing the chip to be manufactured here in the United States. Yeah, that definitely should qualify according to me. I mean, very good chances. So it's your role, Anusha, that will be more important, not just because you're working for the chip industry. You know, people may work for the waste management. They can still be qualified. What if they're doing certain things to save the environment of the entire United States? They can be qualified. It's not just about the industry, it's your critical role that counts the most.
James says, I'm graduating with my master's degree in December and my employer is ready to sponsor me for a visa. Which is the most advisable, H-1B or an EB-2? Well, the answer to that really depends, sadly, on your country of birth. It has nothing to do with your qualifications. It is based solely on where you were born. So if you were born in a country that has a backlog for the green card process, which is EB-2, so what you're talking about H-1B versus EB-2, you're talking about a temporary work visa versus a green card. EB-2 is for a green card. So if you're from a country that is backlogged, filing an EB-2 is not going to do you any good because it doesn't provide you with any way to have work authorization or stay in the U.S. after you graduate. It's not going to give you enough time to get the green card before your OPT or STEM OPT runs out. If you're from any other country, you could probably go for EB-2, go through the whole PERM labor certification, I-140, 485 within the 3 years that you have for your OPT. I'm assuming you're graduating in a STEM field. But if you are going to run out of time in F1 because a green card is not available to you, you need to look at the H1B, possibly an O1. So yeah, it really depends on your country of birth.
Question. My H1B has been revoked and 60 days has been passed. Can I now move to the H4? It depends on how long after 60 days. If it's 61 day, yeah, you can file a H4 and stay. But it's now 70 or 80 days, then you may have to go outside the country to get the H4 stamping. We strongly recommend people who are on non-immigrant visas or adjustment of status visas, please tune in. If there is any other immigration channel, please go and tune in. But we consider our channel is the best, and we do bring in current updates, not just the way we bring it, but it's the questions that we get it. It's the live questions that bring it, that brings attraction to us, because if you guys are not going to ask questions, we can't be mature enough to answer those things. We can't get it in our mind, all these questions, until you ask. So this channel is the best channel for you to tune in. Until you get the green card, at least spend 20 to 30 minutes every week on this channel until you get the green card. Now, why did you let it go for 60 days? Though if you have crossed 60 days and you're at 70th day, definitely my advice is for you to go to India and get the H4 stamping and come back. If it is near 60 days, probably filing H4 would be an ideal for you.
Atanu says, I'm an L1A and we're at the AOS stage and received the EAD. Can my wife work on the EAD while I still continue on L1A? Yeah, that's totally fine. She doesn't really need to use the EAD because she's already authorized to work on her L2, but either way is fine. Her working on the EAD does not have any impact on your L1A. I'm assuming that you are the main applicant on the I-485 in that situation.
My H1B is approved this year. Can I transfer the H1B to different employer before October 1st? We recommend doing it on October 1st, not before October 1st. We have seen some companies do it. We don't know what, at a future date, what the negative consequences would be. I would strongly recommend doing it on October 1st. That would be better. Okay. What? VTR is asking the question again and again. NOIR is not approved. I mean, notice of intent to revoke will never normally be not approved, though. If it's, it will typically, you don't hear any response, though. That means it's a good news. Sometimes they reaffirm their decision, saying that it's fine, but most of the time they don't respond to notice of intent to revoke. Now, if you respond to the notice of intent to revoke, they never responded anything, then practically it's a good news. Now, the rest of the question is a little bit different. I couldn't get the question properly, though.
Banu says, my priority date's July 2012, filed the 485 concurrently May 8th, fingerprints done in June, I-140 approved in July. When can I expect the green card as per the current times? It could be anywhere from tomorrow to a year from now. Processing times are all over the board. Because you filed concurrently, I'm assuming that your 485 is probably at the Texas Service Center or maybe Nebraska Service Center. After your I-140 gets approved, they're generally going to transfer it to the National Benefits Center. From there, it may be transferred to a field office. You might get an RFE for birth certificate or medical if you didn't submit that already. You may want to consider, well, it might be too soon, but I was going to say you may want to consider litigation, but I don't think your date's going to go backwards in October. So it really could be any day now, but it could be forever from now. There's no rhyme or reason to it.
Durga is asking the question, my spouse works for company A, which is the main employer, contractually works for company B. If they lose the company A and they retain the company B's employment, is the H4 plus EAD valid? Absolutely, it is valid. H4 is still valid. H4 is always valid as long as the main applicant is maintaining the H1B status. As long as they're maintaining the H1B, the dependent H4 is valid. And in case they have an H4 EAD, the dependent H4 EAD is valid. If the main applicant loses the H1B, that's when you lose the H4 status. Anything else, Emily?
I think we're out of time. Thanks everyone for joining us. As always, we'll be back next Tuesday with all the latest updates, as well as answering your questions live.
Thank you very much for tuning. But if you want to consult me, Emily, or any of our colleagues, you can always block a time that's suitable to you. my and Emily's times are available online, and you can block a time that suits to you. Thank you very much for tuning in.